Hello, everyone. Attorney Scott Ho here in Reading, Pennsylvania. Thanks for joining us again for another video on PA elder law and my law firm, Resolution Law Group. We have lots of different topics, and our topic today is, do I really need an attorney to prepare an estate plan? The short answer is yes. You won't do brain surgery by yourself, and it's not a good idea for you to be your own attorney in preparing an estate plan. Even if you don't have a considerable estate, there are very complex issues that having the guide of an experienced and knowledgeable attorney is critically important. It's helpful. I'd like to focus in this brief video on 8 questions that you should be able to answer when you prepare your estate plan. So let's look at each of those 8 questions. Okay, question number 1. Do you and your spouse agree about your estate plan? I've been an attorney for 23, 24 years, and guess what? The first thing I learned as an attorney: don't get in the middle of an argument between a husband and wife, because the attorney is going to lose that argument no matter which spouse wins that argument. I say that a little bit tongue-in-cheek, and most spouses are very much on the same page and they see things together, but at the same time, you'd be surprised how many people walk into my office who have very, very different ideas about which child should be involved in their estate, different ideas about where their assets should go, even what to do, even disagreements about, do I want to be buried or cremated, or do I want to have a funeral? Sometimes we have, for the first time, very, very awkward conversations between a husband and wife. So my job is to be a guide and to go through that. You have complicated assets. Maybe some assets are just in one spouse's name. Maybe there's a business, all kinds of things. So question number 1, are you and your spouse clearly on the same page and know exactly how your assets are going to be distributed after one or both of you should pass away? Question number 2, do you have minor children? Or for an older couple, it may be a concern about their minor grandchildren, minor being under 18 years of age. Pennsylvania, like every state, has a Uniform Transfer to Minors Act, so we cannot give a little 5-year-old $1 million inheritance. Even if you thought that was a good idea, which of course it's not, we can't do that. The courts must be involved and supervise any distribution to a minor. But even what if someone is 18? Would you give $1 million or $500,000 to an 18-year-old? I know what I would have done when I was 18, and I would not have made very wise and prudent decisions. So our wills are very detailed. We ask lots of questions, and you can appoint a guardian for minor children who would take care of your child in the event both parents pass away. But in the event of grandparent planning, you don't like to think about your own child passing away before you do, but we want to protect those smaller, younger grandchildren, make sure they inherit, but also make sure that we parcel out those funds slowly over time in a child trust to adequately protect that child until they are older and more mature. Question number 3, do you have children from a prior marriage, or does your spouse have a child from a prior relationship? We live in a modern world where we have blended families, and it's not just a television show, but we have all kinds of families and all kinds of people under one roof with all kinds of configurations. And boy, does that get complicated when we prepare somebody's estate plan. Well, maybe somebody wants one set of children to inherit from this spouse, but not the other spouse. One very common problem, and we provide our free book, Legacy of Love, it discusses this, is usually the distribution plan in a will has 100% going to the surviving spouse, with the idea that in the future, that spouse doesn't change their will, and then at some point in the future, there'll be an inheritance that goes to others. But there's no guarantee of that. And we have the difficulty of saying, do we probate upon the death of the first spouse, or can we avoid probate by having everything going to the surviving spouse? So there are some complex issues to talk through and work with an experienced attorney when we look at different children from different relationships. Question number 4, do you have a child with special needs? What do we do to make sure that that child is specially protected in the future? There are a number of very specific and unique issues. One is, what happens when that child is now older than 18? There's a whole variety of either physical or mental handicaps or disabilities. You as a loving parent want to take care of that child. So the first issue is, what do we do when that child is an adult that you can continue to make decisions and care for them? Sometimes it's necessary to create a special needs trust. A vehicle that we are using much more frequently is creating an ABLE account, an ABLE account. The purpose of that is, what if this special needs child is receiving governmental assistance, such as Medicaid or SSI funding? We don't want to upset the payment streams by having that child inherit a large amount of money and thereby not making them eligible, or the government just kind of sucks up all that money to pay off the large lien. But at the same time, we want that child to have some money from mom and dad or grandparents or whomever to help protect them. So there's some very good vehicles, a special needs trust or an ABLE account that facilitates that. Question number 5, do you have a substantial asset? We do estate planning for all kinds of people. And sometimes people may have a very small estate. They may only have $30,000 worth of assets, but they like the peace of mind of knowing that all their affairs are in order, everything is taken care of, and we're happy to help those clients. But we work with multi-million-dollar clients, and the bigger an estate, the more complex issues there are, the more that we need to focus in on tax planning issues. It's recommended that for high net worth clients, you have a team of advisors that includes your attorney, your CPA, and your financial advisor, and those 3 professionals should work together to create a plan that legally maximizes your tax savings. So if you have complex holdings, if you're a business owner and you own your own business, there are very specific things that we need to do regarding what happens when a business owner passes away. We do that type of sophisticated and complex estate planning. Question number 6, is there any reason that your estate may be contested? I get to see the best of families. I unfortunately get to see a lot of sadness with families. I can't tell you how many times over my long practice, somebody leans in and they whisper to me and they say, Scott, you probably never heard this story before, but let me tell you. And of course, I've heard that story many, many times. There could be lots of different reasons why perhaps one family member or child should receive a higher amount of inheritance. Maybe somebody should receive a lower amount. Maybe some other child has already gotten quite a bit of money and there needs to be some kind of offset. It could be that one child is completely non-communicating and not talking to mom and dad anymore and are completely out of someone's life. It could be that someone has severe drug or alcohol or mental illness problems or a whole variety of things. Doesn't mean that you don't love that child any less. It just means that we're going to make a differential in how the estate is administered. There are very technical, formal rules under the law regarding how your will is prepared, how it is written, how it is signed, how it is witnessed, how it's notarized. Any one of those problems can create a defect that opens up your will to a challenge. So think about, is there anything that you might be do differently that someone could contest the will? They're complaining about how your estate is administered, and is it worthwhile that they would bring a lawsuit to challenge that? Again, having an experienced attorney can avoid that problem before it starts. Question number 7, do you want to leave a portion of your estate to a charity? My father is a Lutheran minister, so we support all kinds of charitable things. And my wife works for a nonprofit entity in fundraising. So Supporting charities is something very, very near and dear to me. There's a whole number of considerations in this category. One is some tax consequences. What's the most beneficial tax treatment for you and your estate? My number one job as an attorney is not to make sure that your children inherit. It's also not to make sure that your favorite charity gets funds. My number one job as your attorney is to protect the people who are writing their will. I want to make sure that you have sufficient assets so that there's enough money to address your future healthcare needs and your retirement. I don't want you to give away all your money just yet. But when the time comes, some people do all their charitable giving during their lifetime. Other people do it through their will. But it's very important how we prepare that and take care of charities. And then further, there are very specific requirements under the law regarding how an estate is administered and probated to make sure that the charities are protected. Again, having an experienced attorney will help you there. Okay, finally, question number 8. Do you own a business, and what will happen to that business? Most family-owned businesses are closely held corporations, meaning whether you formed an S corporation or a C corporation or an LLC or a partnership, there's usually only a single owner or a handful of family members. What happens to that business? My guess is the founder and the president of that business is the glue and the operation, and they know all those things. If that person goes away, will that business come suddenly crashing down that no one knows anything? I have a specialization in my law practice where I represent real estate investors and landlords and people who have multiple real estate holdings. That's a good way to have passive income in our retirement years. You'd be shocked and amazed at how many landlords do not have leases. They don't have a ledger. We don't know which tenant has paid rent. Guess what happens? I have those estates, and then we go around and we contact all the properties and we knock on the tenant's door and say, we're trying to figure out the rent. They say, I'm all paid up in my rent. In fact, I paid cash 6 months in advance. I'm paid well into, if we don't have any, you think that's a made up story, and I'm joking. That's a true story, okay? So having a business continue to operate with a very clear plan and an integration between the business organizational documents and someone's estate plan is absolutely a critical must in a business owner's estate plan. Well, I hope those 8 questions triggered some thoughts for you to think about. There's a lot more than 8 questions. There's 100 different questions. We're here to help you answer those questions and guide you through this process. If you'd like the help of our law office, we charge more for very complex and very sophisticated multi-tax estates. But for most average middle-class Americans, they just need our basic package. For husband and wife, we have a super deal. That is 2 wills, 2 powers of attorney, 2 living wills or advanced healthcare directive, plus our own proprietary comprehensive estate plan. What's the comprehensive estate plan? That's a 3-ring binder that is not only to give you the peace of mind of knowing that all of your affairs are in order, but also for your children or your family or whoever's going to be in charge of your estate, that they know exactly what your financial picture is, where you bank at, where your investment accounts are, do you have any life insurance, what are your funeral planning wishes, what are your personal wishes. We get that all nice and neat and organized. We are an elder law firm based in Reading, Pennsylvania, and we serve Berks, Lancaster, Lebanon, and Montgomery County. We're a little bit unique. We do home visits and hospital visits, and I know every back road in our area, so hopefully maybe there's a time that I can visit with you in person.